We will now proceed to our first witness, John Czygier, who is the surrogate court judge of Suffolk County. While Judge Czygier is coming up, I just want to express again my apology for the fact that because of an error in my office, there were several people who did not get early notification of this hearing, and I'm glad, Judge, you are able to be here. Because I think it's very important that we hear your views.
All right. Thank you. Again, thank you.
And do you swear or affirm that the testimony you're about to give is true?
Yes, I do.
Thank you.
Again, thank you for the opportunity of allowing me to be here. Notwithstanding the short notice, I'll try and put together a presentation that will be brief and to the point. In fact, I did ask that this be adjourned, but apparently this has been long planned. Okay, not that we knew about it. So anyway, let me just give you my background briefly. Okay, I practiced law for 25 years before I became a judge. I've been on the bench about 12 years now as the surrogate judge of Suffolk County. In my capacity as a lawyer, in my capacity as a judge, I've become familiar with adoptions, because that's what surrogates courts around the state do. Quite frankly, in my court, we don't do them that much anymore because the family court has taken it over, but we still are the repository of the records of the adoptions done in the past. I am also the president of the Surrogates Association. I'm a member of the Surrogates Court Advisory to the OCA. And you may say, well, why are surrogates interested in this public health issue? Well, it boils down to one simple fact in my mind, and that is, as a judge and as a practicing lawyer, when representing a natural parent giving up a child for adoption, I was the one who promised confidentiality to the natural parents. And when they came in and made the decision to give up a child for adoption, they relied on that promise. And this is why I think there are some flaws with the bill as presented. And again, Assemblyman Weprin mentioned there's some iteration of this bill has been around for a couple of years. We've monitored it over those years, and we've always been troubled with it. And so I speak on behalf of the Surrogates Association and also the Surrogates Court Advisory Committee. Let me just try and put this together so it makes some sense. You know, the longstanding public policy of this state has been to strike a balance between biological parents' desire for anonymity, confidentiality and privacy, and adoptees' right to access. And for the Surrogates Court, the current law, Domestic Relation Law 114, already effectively balances these somewhat competing interests by permitting access to sealed adoption records for good cause shown. Now, the stated justification for a statutory change is to afford adoptees the same rights as non-adoptees in accessing information related to their birth parents. This premise ignores the fact that natural parents, from giving up a child for adoption, have, in most cases, an expectation of privacy, whether it be for religious, financial, medical, or other personal reasons. It can be presumed that the decision to give up a child for adoption is heart-wrenching. It can also be presumed, I think, that that natural parent may not want to relive that decision sometime in the future, based solely on the curiosity of someone who wants to view the birth certificate. And although cloaked as a public health benefit or aid to the adopted child, I don't see any standard in the bill as presented that they have to allege a medical reason or a need for a research of the biological parent's history. They simply have to come in, file their papers, show proof, and they get to see the birth certificate. And we all know that the birth certificate doesn't contain any information concerning medical history for the most part. But what it does provide are the names of those people who, with the promise of confidentiality, gave up that child for adoption. Now, there is a process in place, okay? If people have a need to access their sealed adoption file, there's a process in place where they come to the court, and on good cause shown, they can access that file. But there's a standard there, and it's up to the judges to investigate whether or not that cause exists to the level where the promised confidentiality to the natural parents should be breached. The problem here is if retroactively applied, the right to privacy and confidentiality of biological parents would effectively be cast aside and promote access, again, merely for the sake of curiosity and eliminate the courts as a gatekeeper. The Court of Appeals in matter of Linda F., 52 New York 2nd, 236, stated, a natural parent understandably can feel deep effects when the records of an adoption are open years after the child was surrendered for adoption. Although the sudden reappearance of the child may often be a source of great pleasure to the natural parent, in other cases it may be a destructive intrusion into the life that the parent has built in the years since the adoption. It may be the source of much discomfort. In some cases, it may even open the way for the child or others to blackmail the natural parents by threatening to disclose embarrassing circumstances. These are not my words, ladies and gentlemen. These are the words of the highest court in this state.
Folks, we need to maintain order here.
If people want to shout me down, don't charge that time against me,
Yeah,
okay? I'm giving you my position.
We're not going to allow people to shout anybody down.
Okay.
Let's listen to one another respectfully.
Well, let me sum up.
Everybody will have an opportunity to make their own comments.
I think you're overlooking the right of the woman who made a decision to give up her child with the promise of confidentiality. You're giving the adopted child the unilateral right to come in and say, we're doing away with that promise that the judge made to you and the lawyer made to you when you gave up the child. So, to sum up, the existing procedure we have to provide for the release of information for legitimate reasons is a procedure that works. The proposals to expand access to information for no discernible reason, other than a desire to know, could result in devastating consequences. Indeed, there are mechanisms in place that allow for natural parents and adoptees who wish to reconnect to do so. The current public health law provisions, adoption support groups, internet services, etc. And again, I'm not unsympathetic to the frustration of adoptees. To me, it boils down to a balancing of the equities. I believe the existing procedures and mechanisms achieve as fair a structure as is possible to protect all concerned. And in short, this seems to be a solution in search of a problem, which sounds trite now, but I said it when the bills first started being passed around years ago when I was making comments, and I say it again. If anyone has any questions, I'm happy to answer.
Yeah, I have a question.
Please, the only questioning will be done by the legislators up here. This is not a debate. This is an opportunity for everyone to come forward and state their views. Mr. Borelli, you have a question?
Yeah. You referenced local law. What was that gives sets up a procedure for adoptees to have a
Domestic
judge?
Relations Law 114.
Okay. So did you ever represent a birth mother in an adoption proceeding?
Sure.
Did you advise them that there is a procedure that their confidentiality might be broken at some point?
Well, you see, that's a good point, because you raise an interesting question. And in Suffolk County, when I was practicing in Suffolk County and handling adoptions there, the birth mother at the time of the adoption, the birth parents, they had forms to sign. They could consent at the time to allow access to the information if the adopted child ever came forward, or they could say, no, I refuse to give consent, keep the file sealed.
But
Now,
you advised your client, though, that there would be an opportunity at some point in the future for that record to be unsealed.
not if they opted for confidentiality. If they said, look, if someone wants to come in the future and access this, fine, I have no problem with it. In most cases, the parent would say, no, I'm giving this child up for a reason, because if I have a family 30 years from now with 3 children and a husband, I may not want someone knocking at my door saying, guess who I am?
Was this law in the books, say, the last time you...
Here's the problem, and again, and this is really the point I was trying to get at with this whole consent form, because you may say in Suffolk
But
County...
I'm trying to get on a different point.
Okay.
So the law existed. It provides a procedure for adoptees at some point in the future with cause to get access to their records. That law is in existence. You
Yes,
represented
sure.
adopted birth mothers.
Yes.
And you failed to advise them that at some point there's a possibility of these records becoming unsealed?
For good cause shown. I didn't fail to advise them. I told them that the only reason, if you refuse to give consent, okay, there is a mechanism in place where they could come back, but they would have to show good cause.
But there's
Okay,
not a
so
100% expectation of absolute privacy. That's kind of a myth, in other words.
Well, I'm not citing myths, okay? I'm citing based on my experience as a practicing lawyer of 25 years and a judge for 12. I'm not citing myths. I'm telling you, representing people and having people appear in front of me. The process that was used in Suffolk County, allowing that person to sign a consent or non-consent, was not uniform across the state. So I can't say whether or not that was offered to every birth mother when they came in to say, okay, if someone wants to know in the future, let them know. That's the problem with this bill, because the mother who relied on the lawyer who said, don't worry, it's going to be confidential, unless there's good cause shown, you are now have an opportunity for someone to come in and say, here's proof of who I am. I want to see the birth certificate. And again, you're cloaking this as a medical rights bill. It's not a medical rights bill. It's someone looking to find out who their natural parents were. And as I say, there is a process in place right now. If a natural parent currently wants to allow or their child to find them, their natural child, there's a registry. If both parties want to get together and come together, that's fine. Okay? I've had people come back to my court who have signed those confidentiality agreements and say, you know, I've changed my mind. I now want to undo that confidentiality. And if someone wants to come in, fine, let them know where I am. Again, I keep reiterating the fact that we're focusing on the right of the adopted child to undo the right and expectation of privacy of the natural mother.
So in proceedings where adoptees have sought to unseal records, how much would a lawyer cost to hire an attorney for that?
They don't have to.
They don't
We
have
have a form.
Okay.
They fill out a form.
And what's the percentage of times that it's been granted and not granted?
Well, because right now what they come in and they ask for is to view the adoption file because they have a medical problem or reason, okay? But quite frankly, those files very rarely contain any medical information. So in most cases, there's nothing there after we review it. Okay.
Mr. Weffern?
Yes. Good morning, Judge. Thank you for coming. We appreciate you bringing your views. The problem, it seems to be that your major objection to the legislation is the so-called promise of confidentiality to the birth parents. Is that correct?
Correct.
Okay, but there are overwhelming situations, and I've spoken to many birth mothers through this process, that they were not promised confidentiality. Do you agree that there are a number of those situations?
I have no empirical knowledge to disagree or agree with you on that.
Okay, and the other thing...
Because I don't know what attorneys tell their clients when they represent them. I know what I told my clients.
Yeah, but the other thing is that New York State law does not seal the birth certificate records until the adoption takes place, while there are many, many situations, maybe even an overwhelming amount of situations, where someone gives up a child for adoption before the child is actually adopted. If that is the case, the records are not sealed when they give up the child for adoption, and they're not sealed until much later when the actual adoption takes place. Are you aware of that?
So are you saying because there's a flaw in the system that way, we should expand the floor and make this an open adoption state?
Well, I
if
don't
that's
think
what you want to do, then propose legislation along that tact, and let's do it. Let's not call it a public health issue when it's not.
Well, there are a number of states that have adopted a more liberal version. There are provisions, and it's kind of as a compromise in this legislation, which would allow the birth mother to be contacted by the health department in the event an adult, by the way, we're not talking about children, we're only talking about adult adoptees, So when the adult adoptee contacts the health department to get a copy of their original birth certificate under this legislation, the health department would then contact the birth mother if they could find them, or the birth father, and ask if they would like to be contacted. Would they like to be contacted through an intermediary, or would they like not to be contacted? My understanding is in states that have adopted this legislation, and I think we're going to hear from a number of people who are familiar with those states' legislation, the overwhelming percentage of birth parents opt for being contacted. So in a sense that this legislation is not only benefiting adult adoptees, it's also overwhelmingly benefiting adult birth parents.
Not in every case.
No, I didn't say every case. Nothing is every case.
Well, but you see, in every case where there was a promise made of confidentiality, I think that promise must be honored.
Okay, so
that's my opinion.
That's fine. So would you support the legislation in the cases where there was no promise of confidentiality?
I would have to look at the legislation. If you want to change the legislation, we'll take another look at it. I understand we'll have further time to comment on this. Yes, Chairman?
Well, I would love to have your comments, how you think we could amend the bill.
Well, I don't think the bill has to be amended. I don't think you need the bill. That's my premise.
Well, that's not the premise of the overwhelming sentiment of over 80 sponsors in the State Assembly.
Well,
150.
I don't want to get into how many 80 sponsors read the bill or understand the nuances of the bill or understand what a lot of the things I've pointed out today about what I see every day in my job. But, you know.
Okay, well, I just wanted to point out, it sounds like your objection is on the confidentiality portion, and there are overwhelming situations where birth parents were not promised confidentiality. And the other problem is that people of means who have that desire, adoptees, to find their birth parents, do find those birth parents, because your fear about someone showing up at the door, that is happening every single day by wealthy people that have the means to hire private investigators, to use the technology that exists today that did not exist when the records were originally sealed, and they have found their birth parents, whether they want to be contacted or not. This legislation will allow everyone, poor people as well as middle-class people who do not have the financial means to hire private investigators to actually travel and other things.
So I guess you're saying it's not really a health care issue. It's an ability for poor people to find their natural parents because rich people can.
Well, that is part of it.
All right.
That is part of it. But there are situations, I think you'll hear testimony today, or we will, from one birth mother who gave up her child for adoption and found out later that the birth father had a congenital heart condition and died of a massive heart attack in his early 40s, and then found out that his father and grandfather had also died of massive heart attacks in their 40s. And she hired a private investigator, spent a lot of money, located her son that she gave birth to.
Is this on my time? I'm just, Chairman. You see, because let me just point something out, because you mentioned we're going to hear testimony
The Q&A process is not on anybody's time. Well,
Okay.
except everybody.
I didn't think it was a question. I thought it was a speech.
Finish. And I'll finish that statement. And as it turns out, she contacted him and alerted him about the congenital heart condition. He saw a cardiologist, which he would not have seen in his late 30s when she knew he was approaching that age, and it potentially saved his life, and he's now living, and he's in his 50s.
Look, with all due respect to, and again, you see, here's one of the problems in that, and I'm sure there are plenty stories like you just indicated of the natural mother who wants this disclosure. You're not going to get anyone to come to this hearing and say, look, I'm a natural mother who gave up my child at the age of 14 because of family reasons, because of religious reasons. My other alternative was maybe an abortion, but for religious reasons, I decided to go through and have the child because I was told, don't worry. You're going to have the child. It's going to go to a good home, and no one will ever know. You can live your life and move on. Okay?
Well, I think we will be hearing from people of that situation.
Remember, you won't be hearing from the people that don't want to come forward because of whatever reasons they can't come forward. So there are compelling stories on the other side, I'm sure.
Absolutely.
Okay.
Thank you, Judge.
Okay, thank you.
Okay, thank you.
May I just ask one
Sure,
quick question?
sure.
Thanks, Judge. Roughly, how many adoptions are there in a county like Suffolk every year?
See, I couldn't tell you that. I really, and the reason they took it out of surrogates court is because there were so many that the family court really is geared up to do them. They have a better investigative system. And let me just say this: as far as statistics go, we get fewer and fewer applications every year from people coming in asking for their files. I don't know why. It's just we only get about a dozen a year, really. In
Right, now that's a dozen in the surrogates court or a
Surrogate-
dozen
surrogates court.
countywide?
No,
And do you have
surrogates
any
court.
sense countywide?
No,
how-
I really don't. I can't. I'm sorry. I'm not prepared
So
to address that.
out of all those adoptions, and again, you've told us there were so many that they ended up not going to surrogates court, but to family court. Out of all, the proceedings involving adoptees, how often does it occur in a county like Suffolk that the birth mother comes to court or does whatever administratively has to be done to waive confidentiality?
Well, you see, I don't think she does have to come to court because she could go to the registry, and that would kind of circumvent the whole thing.
And
but
the rough number of occasions on which that occurs?
Well, like I said, the natural mother coming to my court, I've done it only once. I've only had one natural mother come and say, I'm at a point in my life where maybe I would like to reconnect and find out what happened to the child.
Thanks,
Only
Judge.
once. Okay.
Thank you.
Thank you so much.
Thank you.
Okay.